Good morning. I want to welcome you to the Washington Legal Foundation and our media briefing program. My name is Glenn Lambie. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 38th year of public interest law, policy, advocacy, and education. In addition to putting on programs such as this and web seminars and running a blog called The Legal Pulse, we have a publishing side called the Legal Studies Division, which puts out publications on a wide range of issues. One of the papers that we did is going to be discussed a little bit today by our speaker, Lawrence Kogan. For those of you who aren't familiar with our litigation side, that's been our core for many, many years. We litigate in Supreme Court and lower federal and state courts as well, participate in regulatory activities, file comments, both at the state and the federal level, and we have all of this activity on our website, so I please encourage you to spend some time on there if you're online with us. I want to introduce our moderator today. The Honorable Douglas Ginsburg was appointed to the U.S. Court of Appeals for the D.C. Circuit in 1986 by President Ronald Reagan. He was Chief Judge of that court from 2001 to 2008. He has taken on senior status and is also a full-time faculty member at the George Mason University School of Law. Prior to his appointment to the D.C. Circuit, Judge Ginsburg was a professor of law at Harvard, served as Assistant Attorney General in the Justice Department's Antitrust Division, and most relevant for today's program, he was Administrator of the Office of Information and Regulatory Affairs at the Office of Management and Budget. Judge Ginsburg, if you could get us started.
Thank you, Glenn. Thank you for including me in this event and for reminding me of why I'm here. And I think one of the reasons I'm here actually is that federal courts routinely hear cases in which scientific or otherwise technical subject matter plays a large role. And this is particularly true for the D.C. Circuit and has been for several decades, where we hear particularly petitions challenging or seeking review, I should say, of agency regulatory decisions. Mostly rulemaking, in fact. Because federal judges are fairly obviously not scientists or technical experts, and because the Congress delegates rulemaking authority to the agencies precisely because they do have such expertise, federal courts typically defer to some degree, and some quite deeply, really, to the judgments of these regulatory agencies. Most important for scientific and technical rulemakings, agency action under the Administrative Procedures Act is reviewed in accord with the arbitrary and capricious standard. Standard is one that enhances, that was intended and hoped to enhance both the efficiency and the legitimacy of government action, which relies heavily on specialized agencies to administer these statutes, typically fairly complex statutes such as the environmental laws, and to issue technical regulations. And there are a lot of those regulations. According to the most recent report from the OMB to the Congress, in the period, the decade 2004 to 2013, the federal agencies, including both executive departments and the so-called independent agencies, published 37,000 final rules in the Federal Register. OMB reviewed 3,000 of those, 3,040 of those through OIRA. And of the rules reviewed there, 569 were considered major rules because of the expectation that they would have an economic effect in excess of $100 million. That's essentially a cost for regulated parties. Drilling down into the most recent numbers, there's a best estimate that about 3,500 rules were issued by federal agencies last year, 2014. And during that time, OMB reviewed 452 proposed rules. The average time that it took was a little over 4 months, 127 days. Those rules occupied 24,861 pages in the Federal Register, which, as you know, has to be read with a magnifying glass because of the small type. And an astounding number, but still short of a record that was set the year before, in 2013. About half of all of these regulations are coming from 6 agencies. The Departments of the Treasury, of the Interior, Commerce, Transportation, Health and Human Services, and the Environmental Protection Agency, which I must say, if it doesn't issue the largest number of scientifically complex regulations, issues the most complex and technical regulations of any of these agencies typically. The regulations in question span the horizon: food inspection and labeling requirements, energy efficiency and conservation standards, sanitation regulations, of course, environmental regulations, healthcare standards, air pollution, greenhouse gas standards, and the like. Because OMB reviews only a fraction of these rules that are issued every year, and because the agencies frequently make policy outside of the rulemaking process, OMB's longstanding Information Quality Act guidelines are no less important a tool than is active OMB review in helping to promote sound scientific decision-making by the agencies. Those guidelines, the IQA guidelines, are aimed at, quote, ensuring and maximizing the quality, objectivity, utility, and integrity of information disseminated by federal agencies, close quote, by, among other things, promoting information transparency and the peer review of scientific data. There's a debate as to whether the guidelines, in fact, have proven too much of a barrier to agency action and instead should be enforced, on the other hand, should be enforced more strictly than they are now. So those are the two sides of that. But given the effect of agency action on the economy and on our legal structure, on average, bear in mind, in the past decade, the agencies have issued 26 major rules for every one law enacted by the Congress. Anyway, the key thing is that the scientific soundness of agency decision-making is critical. So I look forward, and as we all do, to hearing the views of our panelists today, Paul No, Nikesh Jindal, and Larry Kogan, about the role of the OMB in promoting science-based government. And I also look forward to the questions from our audience out there in the internet world. Paul No is going to get us started. Paul's career has been one long, deep dive into regulatory policy. You'd look none the worse for wear. He served in government as a counselor to the administrator of OIRA. Before that, a senior counsel to 3 different chairmen of the Senate Governmental Affairs Committee. Now he's he's a lawyer, been a lawyer in private practice, and now he's working at the intersection of these forces, representing regulated entities in his role as Vice President for Public Policy at the American Forest and Paper Association, and before that at the Grocery Manufacturers Association. Among other things, I know Paul's eager to address the question whether OMB, OIRA, is a good gatekeeper for science in the regulatory process, given its larger mission, its modest staff size, and the fact that it's essentially part of the White House. Paul, you want to get us started?
Thank you, Judge, and I want to thank Glenn for the invitation to be here to talk with you all today on a rather daunting topic for those of us who are alums of OIRA, whether OMB can be an effective gatekeeper in the area of science and federal regulation. I just want to say at the start, I'll do a disclaimer. I'm speaking today in my personal capacity, so the views I express don't necessarily reflect those of my current employer, and I'll try to be as controversial as possible. And I also speak from the perspective I gained when I served as counselor to the OIRA administrator when John Graham and I were there in the Bush administration from 2001 to 2006. So any mistakes I make today are my own. Let me just start with a couple of simple points. And the first is that OIRA can't help but be involved in issues related to regulatory science policy. Because it is really at the intersection of questions involving benefit-cost trade-offs in federal regulation. That's its assigned role by presidential executive order. So when it's involved in questions involving benefit-cost balancing for environmental health and safety regulations, Typically, of course, for major regulations of this type, the benefits are determined through the use of a risk assessment. And there are a couple explicit directives in the current executive orders that are on point in this regard. The Clinton executive order that still governs regulatory review talks about the need for agency regulatory decisions to be based on the best available scientific and technical information. And President Obama's executive order, 13535, that supplements the Clinton order, directs agencies to ensure the objectivity of technical and scientific information used in regulatory decisions. And both orders, of course, put OMB and specifically OIRA in the role of helping to ensure the principles of those orders are carried out. It's a fair question to ask why every president since Richard Nixon has wanted there to be some form of centralized review, and it's a fair question to ask why any clear-headed president would think that an office of maybe 50 professionals could somehow manage the regulatory state. But the simple answer is if OIRA didn't exist, it would have to be invented, because the magnitude and importance of the regulatory process and of federal regulation is so huge that no clear-headed president could think there shouldn't be some form of management in an office that will ultimately ensure that the president's priorities are reflected in agency regulatory policy. There's also the basic problem that there are sometimes differences between the agencies on particular issues, and there has to be a way to resolve that, and OIRA serves that function. Again, OIRA does also answer ultimately to the president. It has to ensure that presidential priorities are reflected in policy. Now, how OIRA can function in this role, as small as it is compared to the agencies, well, there's a few ways in which it has certain ways to increase the power of the review function. One is that OMB review is often the term that people use, but it's really a misnomer, because what OIRA is involved in is interagency review. And other agencies have their own experts that are often very relevant to particular issues in another agency's regulation. So when the OIRA staff get a draft regulation from an agency such as EPA, they will distribute it to other agencies that are interested in that and have expertise that can be brought to bear on the rules. So there may be scientists, for example, at FDA and USDA that have, or the Department of Energy, that have very important expertise to and views to provide on that rule. There's also the issue of in-house expertise, and I'm a strong believer that OIRA should have scientific expertise and technical expertise. And at the time I was there, the administrator, John Graham himself, had great expertise in decision science and risk analysis, but he had a top priority of expanding OIRA's expertise beyond the traditional realms of economics and policy analysis to include scientific areas such as toxicology and epidemiology, as well as public health and engineering. And I think that was a big boost to OIRA in its ability to do its job well. And those kinds of expertise have continued to this day at OIRA, which I'm very happy that that's the case. A third thing that helps OIRA handle this formidable task is prioritization. The judge gave some daunting statistics about the number of regulations that are issued. What OIRA does is focus its limited time and resources on the very most significant rules. Typically, the rules that get the most attention are those that have over $100 million impact. That's a much smaller number of rules per year. You're getting from in the realm of 4,500 to 5,000 down to maybe 100 a year. And I once heard a back-of-the-envelope estimate from one of the career staff that that's probably 75% of all regulation is represented in that much smaller number of economically significant rules. And OIRA also prioritizes on what it thinks are the most important issues and where it can make the most important contribution, where interagency review can make the most important contribution. An additional way that OIRA can have greater influence than just its numbers is through the use of guidance, which it can provide to the agencies. When I was there, that was done in several respects. One was simply stricter enforcement of the existing guidance that the Clinton administration had in place. Just as one example, John Graham returned 20 rules in his first 6 months. That was more than the total number of returns that had been done in the prior 8 years of the Clinton administration. And I think that sent a message that OMB was very serious about the quality of regulatory analysis. In addition, OIRA updated that guidance for regulatory agencies on how to do a proper regulatory impact analysis. It also worked with OSTP and the agencies to refer some particularly important risk analyses to outside authorities for an independent peer review, such as the National Academy of Sciences. And I think that is also a significant way for the interagency review process to have an impact on science policy. And finally, following enactment of the Information Quality Act, OIRA expanded its information policy function. It issued government-wide guidelines on information quality and worked with the agencies as they developed their own particular guidelines for their particular programs, and Larry Kogan will speak about that later. A final point I have to make about OIRA's capacity is while the professionalism and talent of the OIRA staff is truly exceptional, and I'm very proud to have worked with some of the best public servants I think exist anywhere in the federal government. Their effectiveness really depends on whether their best professional judgment is given serious weight by the political officials at OMB, at other agencies, and at the White House, and that's very critical to their effectiveness. So having spoken just briefly about how I think OIRA should and how I think it really can effectively engage in policy issues related to the use of science in rulemaking, I want to talk a little bit more about why OIRA should be involved. And in doing that, I'd like to touch on the often very heated debates that swirl around the use of science in developing regulations. At the outset, I think it's important to think about the source of the problem. A common argument by critics is that the root of the problem surrounding science and regulation is that political officials try to intervene and actually control science. And to be fair, political officials should not be trying to change science. If the earth is round, it's round, and we should take it at that. But I think there's another argument that is very compelling, and that is that there's a problem when scientists try to control policy. And that's an issue I want to talk about in a little bit more detail. In its report on improving the use of science in regulatory policy, the Bipartisan Policy Center put it this way: a tendency to frame regulatory issues as debates solely about science, regardless of the actual subject in dispute, is at the root of the stalemate and acrimony all too present in the regulatory system today. And I very much agree with that statement. As former OIRA Administrator Susan Dudley put it, science in and of itself rarely is sufficient for making policy decisions. First, while science is critical for answering the question of what is, or predicting outcomes that might result under different scenarios, it's much less helpful for the normative policy decisions about what should be. Sound policy decisions balancing trade-offs to maximize societal well-being depend not only on scientific assessments of risk, but also on other considerations such as economics, the law, ethics, and the will of the people, which is politics. Second, scientists will never have complete information to predict outcomes with perfect certainty. So risk assessors use what is called risk assessment policy in the National Research Council's classic Red Book, Improving Risk in the Federal Government. And the Red Book put it like this: in each step of the risk assessment process, a number of decision points occur where risk to human health can only be inferred from the available evidence. both scientific judgments and policy choices that may be involved in selecting from among possible inferential bridges. And they have to be, we've used the term risk assessment policy to differentiate those judgments and choices from the broader social and economic policy issues inherent in the risk management decisions. Policy officials, Congress, and the public often are unaware of the significant influence these risk assessment policy choices have, or that alternative assessments that may be equally plausible might have. When the policy of the regulatory agency is to err on the side of overstating risk, it will often rely on one-sided policy choices at each key decision point in the risk assessment process, which compounds the conservatism and often precise-sounding risk estimates. Policy decisions that are reported as if they are based on science, in fact, may be driven by these agency staff judgments about what policy should be. And these policy choices typically are not transparent to the decision maker or to the public. So rather than a small group of individuals having a de facto monopoly over these policy choices, I would argue it would be preferable to have them be transparent and the subject of the kind of peer review that interagency review can provide, or in some cases by outside authorities such as the National Academy of Sciences. As the Bipartisan Policy Center put it, some disputes over the politicization of science actually arise over differences about policy choices that science can inform but not decide. For example, decisions about how much risk society should tolerate or what actions should be taken in the face of scientific uncertainty are not science questions, but rather they concern policy and values. Matters such as risk and uncertainty need to be informed by scientific results, but science cannot tell policymakers how to act. And they go on, policy debate would be clarified and enhanced if a systematic effort were made to distinguish between questions that can be resolved through scientific judgments and those that involve judgments about values and other matters of policy when regulatory issues comprise both. This transparency would both help force values debates into the open and could limit spurious claims about and attacks on science. With that, I will conclude my remarks and look forward to the rest of the discussion.
Thank you, Paul. Your timing was impeccable. We're going to turn next to Nikesh Jindal. Nikesh is currently counsel at King & Spalding, where he practices in the firm's business litigation and healthcare practices. Like Paul, however, Nikesh has devoted a substantial portion of his career to government service. He served as Associate General Counsel at OMB, where he provided advice on legal and regulatory issues, reviewed significant rulemakings, and worked directly with the agency staff to resolve legal issues. Prior to his stint at OMB, Nikesh served as a senior counsel at the Department of Energy, where, among other things, he helped draft regulatory guidelines. He intends to share with us his view on whether OMB's role and interest in the area of science has remained consistent across administrations over time. Thank you. Nikesh?
Thank you, Judge Ginsburg, and I want to echo Paul's thoughts. It's my pleasure to be here. I think this is a very important topic that spans not only our time in government, but is continued in the time since. As Judge Ginsburg alluded to, I have experience both within the government, but also now in the private sector, representing a variety of clients that have issues that are either before the agencies themselves or before OMB, or sometimes that reach Judge Ginsburg's forum and reach the courts. And from that perspective, I just wanted to share a couple of different thoughts, which is that the importance of OMB to this process, to reviewing science and coordinating scientific determinations, I think can't be understated. The only other resort, if in the absence of such a function, would be a purely litigation-oriented regime, which I think is not suitable and for a variety of different reasons. Among others, I tell from personal experience about some of the clients that I've counseled, clients and companies are often reluctant to sue the regulator for a variety of good reasons, one being that it's hard to go to war footing and say all sorts of nasty things about your regulator in court and then try to intersect with them in a nice and friendly way on a day-to-day basis, trying to achieve regulatory compliance. So there's a natural reluctance for regulated parties to sue and to bring their claims in court. And then beyond that, as Judge Ginsburg alluded to in his remarks at the beginning, there's also some bit of reluctance among the courts to kind of wade into kind of complex and technical scientific issues, particularly if the agency is able to point to some type of evidence in the record saying that it considered the issues. Courts may naturally defer to that type of judgment by the experts agency and avoid really getting into whether or not the science is really technically accurate or the most complete determinations that are being made by the agency. And so I think that speaks to the role and the importance of the OMB function to make sure that these scientific determinations are being made in kind of a comprehensive and thorough manner. I think there's a Supreme Court case from last term which illustrates this point about how these cases, if they do reach the courts, are litigated. It's the Utility Air Regulatory Group versus EPA case involving greenhouse emissions and how to potentially subject stationary sources to those potential requirements under the Clean Air Act. And the underlying dispute there was that for a long period of time, there have been express statutory thresholds that applied to stationary sources such as plants, buildings, and the like about the types of pollutants that they can emit and before they have to undergo regulatory controls under the Act. And the EPA in the last few years had made the determination that greenhouse gases qualified as pollutants under the Act such to trigger the potential regulatory requirements. But attributing greenhouse gases as a pollutant under the Act would have expanded the scope of the applicability and subjected an extraordinary broad number of businesses such as hospitals, health cares, nurseries, and the like to these potential requirements. And so what the agency decided to do is to increase the thresholds in the statute applicable to pollutants, at least when with respect to greenhouse gases, by a range, I think, of 100,000. And the court, when it reviewed this, found that the agency had exceeded its statutory authority. It said that it didn't have the power to rewrite the statute and effectively increase the thresholds in that manner. And indeed, that in and of itself showed that the greenhouse gases were most likely not to be considered pollutants for purposes of the Act. What that case shows is that those types of legal arguments about the statutory authority of the agency and how it's implementing it are the types of legal arguments that are easier to kind of frame before a court and more likely to get traction. But if you go back and look at the record in that case, there are all sorts of comments that parties had made in the record that the EPA had failed to consider the science, that indeed had relied extensively, if not almost exclusively, on international reports that were not credible, and that had discounted the costs and benefits when it did its analysis in an improper way. And those scientific arguments, while potentially valid, and I wasn't involved in the case myself, but the legal advocates, and at least in presenting the case, diminished and failed to kind of give those arguments front and center importance in the briefing, and I think probably for good reason, recognizing that it may be harder to prevail on those type of tricky, technical, scientific issues rather than kind of the clean, bright line statutory authority arguments that are often a better way to kind of to litigate these cases. And that's just a long way of saying, and through this example, that litigation is kind of a last resort for entities that are unhappy with how regulatory determinations are made and whether or not the proper science or proper cost-benefit determinations are being assessed, but that it's not a perfect substitute and that there has to be this intermediate function or role played by OMB, which it does, to make sure that these agency reviews are being done in a kind of a comprehensive and thoughtful way. And my own personal experience, having been both at the Department of Energy and at OMB, is that, as Paul was alluding to, that it's not simply that you have a small band of people at OIRA and OMB that are performing this function. I can attest from my own experience at DOE that for some of the EPA rules that Paul was alluding to, that we were often brought in kind of early in the process, early in the review process, because we did have people within our agency, scientists, that had expertise that could help lend to the whole review process, and that there was kind of a coordinated review where there were meetings and discussions among OMB, OIRA officials, Department of Energy officials, Council of Environmental Quality, OSTP. There was just kind of a range of experts within the government that were brought to bear in a way that wouldn't be possible if OMB didn't serve that kind of clearinghouse and intermediate function. And one of the things when I was at OMB that I was at OMB between 2006 and 2008 that we tried to do to actually enhance the approval kind of intermediate clearinghouse function of OMB on scientific and technical issues was Executive Order 13422, which related to significant guidance. And prior to that point in time, the Executive Order 12866 applied to significant agency regulations. And as Judge Ginsburg was alluding to, there's a range of regulatory pronouncements that occur outside the scope of APA notice and comment rulemakings. And so the motivation behind EO 13422 was to try to sweep in some of the most significant guidance, sub-regulatory issuances, to allow for that type of intermediate clearinghouse review by OMB and OIRA in a way that wasn't being done prior to it. And so there was all sorts of significant scientific technical judgments being issued and guidance, and primarily by EPA and FDA and other agencies that were unbeknownst to the rest of the government and wasn't subject to the same comprehensive review process that perhaps a significant regulation had been subject to. I thought it was an important initiative, and it was issued by President Bush in January 2007, and it could range from several matters of science relating to bioequivalence determinations that often are made by the FDA when generic drugs are brought into the market, to the regulation of the food and drug supply by FDA and the like. But it was rescinded in January of 2009 and by the current administration in one of their first acts in office. And so it's basically created the situation that existed prior to its adoption, in which there are large forms of guidance and other sorts of sub-regulatory documents that are being issued by agencies now that are outside the scope of the formal OMB, OIRA review process under 12866. And I think that speaks to even more to the points that I think Larry will speak to about the application of IQA guidelines and requirements to the scientific analysis by agencies, because it potentially could apply more broadly than even the OMB formal review process does under 12866. And so the importance of science is not only simply limited to the areas of notice and comment rulemaking, but also these areas of guidance, which may further speak to the importance of the IQA issue that I think Larry will address. And so, in closing, the only other thought that I'd offer is that there are lots of other kind of different reform proposals that have been talked about and written about how to improve or enhance kind of the technical and scientific review process within the government. And there are a couple of thoughts that I think may actually align with actually making judicial review simply a little bit more tenable or more easy for the courts to kind of grapple with when it comes to these issues as well. And one thought that's been proposed is that particularly, and it may be have particular force with respect to standards that are constantly, periodically or constantly revisited or enhanced or modified, but to the extent that agencies are periodically revising standards, such as air quality standards or the like, rather than taking the baseline as no standard and completely doing a cost-benefit analysis again from scratch, or looking at the science based on having no standard and whether we should adopt a heightened standard, perhaps there should be some type of recognition or importation into the consideration, into the case law, and to the like about the existing baseline level and whether there's science or cost-benefit analysis that justifies taking the existing standard and increasing it or adjusting it in any way. And so the analysis isn't based on no standard versus a heightened standard. It's that there's a recognition that we have a default baseline status quo standard, and what's the justification to make it from X to X plus Y. And that may be a way to kind of simplify the issues in a way that makes the science and the technical analysis more easy to grasp, not only for the regulated party and the public, but also the courts, recognizing that rather than just analyzing the science on a blank slate, we're analyzing it vis-a-vis an existing baseline. So with that, I think I'll conclude my remarks and happy to answer any questions that come up after Larry gives his presentation.
Thank you, Nikesh. Our next and last speaker is Larry Kogan, Managing Principal at the Kogan Law Group. Larry's written extensively on the topic of regulatory policy, including most recently a paper concerning the Information Quality Act. Larry brings to his writing and to this panel substantial experience briefing government officials on substantive policy issues. In addition, he's founded the Institute for Trade Standards and Sustainable Development, a not-for-profit organization dedicated to facilitating, quote, objective, scientifically and economically benchmark and justified regulations. Among other things, Larry will talk to us about the areas in which he thinks more robust action from OIRA is needed.
Good morning. I do apologize for my tardy appearance, but trying to traverse the city in traffic mode is a challenge, to say the least. I thank the speakers for joining me in today's panel, and I thank for Washington Legal, Glenn Lammy, for organizing and convening such a panel with such esteemed moderator. I'm going to try to zoom in and out from a large picture, small picture perspective. Having recently delivered a presentation in Hong Kong for the Inter-Pacific Bar Association on international trade and environmental matters. And what it did was it raised my awareness of the horizontal chapters in the Trans-Pacific Partnership Agreement and the Transatlantic Trade and Investment Agreement, TTIP and TPP, which happen to make reference to data quality within an international standard known as good regulatory practice, or regulatory quality, which can be found in the OECD, APEC, and even in the World Governance Index. Apparently, data quality, along with cost-benefit analysis and regulatory impact analysis, are deemed to be good regulatory practices by government because they inject some objectivity into the aperture, into the degree of stringency of regulation and the basis for the regulation. What was striking to me was that even though data quality was mentioned, there was no mention of Information Quality Act, though there was mention of cost-benefit in RIA, because RIA seems to be the common principle in the horizontal chapters of both of those agreements. And TPP is more along the line of aligning processes for regulation, how to approach regulating environment, health, safety, and consumer protection rules. Whereas TTIP, which is the European agreement, mostly looks at aligning the regulations themselves in a more substantive matter, in addition to the procedural matter. The IQA is a procedural statute that basically applies to every substantive law statute that goes across, that's promulgated by federal agencies, including White House offices. And the IQA, as my working paper reveals, looks to how the science that agencies use, either as standalone studies or as support for major regulations, how that science was developed and reviewed. It injects a degree of objectivity that agencies might not find within their own houses, and as a result, there are those who are for it and those that are against it. And unfortunately, just as with any policy, there's always a politics behind it. So people can surmise who's for it and who's against it. You have to take into account, when you look at the Information Quality Act and how it imposes a rigorous peer review standard, depending upon the economic impact and the novel and controversial nature of the science and the rule which it supports. There are two basic levels we're talking about here: influential scientific information and highly influential scientific assessments. And the difference between them, assuming that you have controversial, precedent-setting science that is at the frontier of estimation and anticipation, you have to look at the economic impact. And the economic impact trigger for and ISI is less than that for a HISA. HISA is over half a billion dollars. Now, for instance, an FDA dietary guideline doesn't rise to the level of a regulation. However, it can have an economic impact that rises to a couple $100 million, or at least or more than $500 million. As a standalone study, it may have been developed to impose some type of chilling effect on the marketplace so that they change their behavior. On the other hand, you could have, for instance, in the case study that I provided in my working paper, the greenhouse gas endangerment findings that are based on 28 key reference documents, core reference documents. And each of those, and most of which are over $500 million in impact individually. So when you look at a HISA, as opposed to ISI, the standard is external peer review. The standard imposes more rigorous panel balance requirements. It imposes more rigorous conflict of interest requirements, and it imposes more rigorous independence, both from a financial and intellectual sense standards. And that's where the rubber hits the road. And if the agencies perform the necessary external peer review, which they're supposed to do under the standards, then supposedly they will get to produce, develop, and review a higher level science document that can be justified as support for regulation. Now, the greenhouse gas findings resulted in a host of different economically significant regulations that followed the finding. And other rules also are based on HISAs that have resulted in proposed rules. For instance, the new performance standard for new coal builds, the Clean Power Plan for existing coal builds, the proposed NACWA standard for ozone under Clean Air Act, and you can even go and look for Clean Water Act rules, such as the Water Connectivity Rule, that essentially supports, based on hydrologic studies and contiguity studies, the proposed redefinition of waters of the U.S. You could even go into Endangered Species Act classifications. A recent request for correction, which is the administrative procedure under the IQA in order to tee it up for potential later judicial review, was filed with the Department of Interior 2 months ago in connection with the department's classification of the sage grouse as endangered. You could also even look to the Patent Act to find some type of request for correction that has to do with the study that the White House put out that wasn't peer reviewed. So the IQA's got broad applicability. The IQA does impose standards that are definable, especially at the HISA level, for the most significant in economic and policy terms of the scientific assessments that the government marshals as support for a rule or rulemaking. Now, one of the things that's very interesting that is highly debated is whether the IQA is judicially reviewable. And there are those who have in the past attempted to file suit under the Administrative Procedure Act, or actually more likely under a substantive law statute, which have found it very difficult to secure jurisdiction of the federal court, and have found it very difficult to secure standing, Article 3 standing. As my working paper sets forth, the way that they framed the case was that a right to correct information was provided by the IQA, or a right to access to information. I submit that the right to access really is more properly covered by FOIA, and the right to access to information in many states is not honored under common law. So where does that leave you? It leaves you with bad case law to start with. So in the working paper, we proposed looking at the IQA within its larger statutory framework, which is the Paperwork Reduction Act. Paperwork Reduction Act's main chief objective was to reduce burdens on taxpayers created by paperwork that government agencies put forth or that government agencies seek to collect from the public. The IQA basically implements the push function of the Paperwork Reduction Act, which is to push out information to the public and trigger responsible actions of the public or paperwork obligations in turn. Now, the Paperwork Reduction Act, again, its chief policy objective is to reduce the burden by paper. In the context of the IQA, we're talking about highly influential scientific assessments not properly peer-reviewed, which impose their own series of burdens, which include both cost-related and just compliance-related burdens. If you look at it that way, it's a negative right not to be burdened, as opposed to a positive right to an entitlement. And a negative right not to be burdened is the same thing, or analogous to a constitutional right not to be impeded upon with respect to constitutional rights that are recognized in the Constitution and the Bill of Rights. Looking at it that way, one could consider bringing a case under the Administrative Procedure Act, arguing that a particular scientific assessment, a highly influential one, promoted as support for a major regulation, or many scientific assessments that qualify as HISs supporting a major regulation, was not properly peer-reviewed, was suffering from significant constitutional conflict of interest, both institutional and individual, and that based on the facts of the pleadings, this case may be able to establish jurisdiction. You have a final agency action, which can be said to be the final, should I say, response to the request for correction that's submitted during a notice and comment period. Now, usually, the way the agencies hold the responses to the request for correction submitted in a rulemaking APA period, notice and comment period, they won't respond until they issue the final rule. That doesn't give you another shot at the appeal part of the statute. So it basically locks you off. If you were to appeal it, in connection with a petition for reconsideration or review of the rule itself, you would end up getting tied up in the Clean Air Act, for instance, and you wouldn't be able to escape the vortex of the Clean Air Act, which would basically apply Chevron deference to the substantive law statute as interpreted by the agency. Taking a separate pathway, one could file a separate cause of action under the Administrative Procedure Act in the name of the Information Quality Act, seeking an injunction calling for the agency to re-peer review those scientific assessments that have been found non-compliant with the IQA conflict of interest, independence, or panel balance standards. That would be brought in a federal district court, and it would have nothing to do with the rulemaking itself, because the whole inquiry focuses on how the agency developed and reviewed the science, not whether the agency acted in an arbitrary, capricious manner with respect to reaching its rule. It's a totally separate focus. It's a totally separate remedy at law, because a review under the Clean Air Act cannot provide you with the same remedy that a review under the Information Quality Act can provide you. And that is something that I would actually pose to Justice Ginsburg, because the point is, there are 3 cases out there that I've looked at that were all brought in the last 4 or 5 years, in which the D.C. Circuit Court didn't get to the science behind the rule. We're talking about Coalition for Responsible Reg v. EPA, we're talking about American Petroleum Institute versus EPA, and we're talking Mississippi v. EPA. In each of those cases, the litigants either did not plead the IQA as a separate cause of action, but rather it pleaded it as incorporated within the Clean Air Act. So they tried to imbue the Clean Air Act with a level of quality in the development and review of the science. The court did not have anything positive to say about that approach. Because basically, under Chevron deference, not only does the court defer to the expertise of the agency in interpreting the statute as implemented in the reg, but it also gives almost a super deference to the science as developed and reviewed by the agency, because the court, in its own words, lacks the expertise. Now, this is where OMB review administratively has a key role to play. The question is, how much time will it take for that review, and whether it would foreclose any option for judicial review given the fact that litigants are impatient. And the rule could be adopted in final form, and the science continues to apply, and it would take a longer time to obtain a resolution. With that in mind, I invite questions and answers, questions from all of you, which we will all try to answer to the best of our ability. Thank you very much.
Thank you, Larry. I have a question for you, and I'll get us started and then turn it over to 2 other colleagues to see what they have to say before going to the audience. how would a petition for, well, a challenge in district court to an agency's disposition of a final disposition of a request for correction under the IQA differ from the kind of review that would, or the kind of scrutiny that would be given in a challenge to a rulemaking using the arbitrary and capricious standard? Would it not be, since you're under the APA, the arbitrary and capricious standard in the type of action you're proposing?
Well, the focus of a petition for a review of a rulemaking really focuses on the decision that led to the rulemaking, whether the agency has a rational basis for reaching that decision. And it's the rule, not the science, that's supporting it. Under an IQA action, you're focusing on how the science that the agency uses, which in most cases is either internally developed but really mostly third-party developed, how they peer-reviewed the science, and how they selected from among the different pieces of scientific information. Now, in my working paper, in one of the footnotes, I make reference to the fact that science obtained by means of grant funding may be different as far as peer review standard when compared to science obtained through procurement contracts, such as through a defense contract. And that whole focus is the focus of an IQA action, is how the agency went about developing, obtaining, and reviewing the science, taking into account the source of the science and the degree to which the science is relevant, the degree to which the science is accurate, the degree to which the science is reproducible. Because the whole point of IQA is to ensure the integrity, the objectivity, or accuracy, the validity, and the reproducibility of science. Science, if nothing else, must be reproducible unless you are not seeking any type of assurance.
So that describes the subject that would be under scrutiny, but what about the standard of review?
Well, the standard of review obviously would, it may be an arbitrary capricious standard of review based again on the methods by which the science was developed and peer reviewed. If the agency, if I may posit a hypothetical, assuming that it is shown in the pleadings and through evidence that an agency improperly peer-reviewed a number of assessments that support a major rule. Okay, but let's not even look at the rule. Let's just look at how they peer-reviewed it. Did it meet the IQA guidelines applicable to HISA? Assuming that that evidence shows that they did not, the agency did not meet those guidelines, which are, I would argue, justiciable because they are defined at the HISA level much better than they are at the ISI or other level, then wouldn't a court reviewing the rationality of the rule in the DC Circuit, wouldn't they have to reconsider whether Chevron deference should be accorded to that agency on the rule?
Interesting question. The Chevron deference would not be, I think, would not be applicable to the guidelines themselves because there are multiple agencies applying them.
Well,
go ahead.
Primetime Vilsack in the DC Circuit basically held that those standards are binding because they're legislative guidelines, they're not interpretive guidelines. Under me, they're binding and have full force and effect of law. As a result, and the court also ruled that OMB should be given deference, not the substantive law agency on the rule. So if OMB's review of the agency's compliance with the guidelines shows noncompliance, that should be a very serious consideration of the court in whether to basically impose the burden on, let's say, on EPA to show that their reliance upon those flawed peer-reviewed scientific assessments was justified and that Chevron deference perhaps should not be granted unless the agency can prove otherwise.
Let me direct this to Paul then. Paul, you were counselor to the administrator when the IQA guidelines were promulgated. So at that time, what were you hoping the guidelines would accomplish and what's actually happened?
Well, we certainly hope that that the guidelines would accomplish what Congress intended, namely to improve the quality the most important documents and information that agencies rely on to issue regulations, to create regulatory policy. We wanted greater objectivity, especially in technical and scientific information. The OMB guidelines, built on, I guess is a better way to put it, the risk assessment provisions that Congress had put in the Safe Drinking Water Act of 1996 to try to improve the quality and objectivity of agency information. And, that was our intent. I think as far as what impact it had, I think the jury's still out on that. I think it takes a while to create a culture change in government, and it takes time to sort of turn the ship. And as I said in my remarks at the beginning, a lot of OIRA's effectiveness depends on whether or not the best professional judgment of OIRA's staff is given weight at OMB and in the White House and by other agencies. And so that can wax and wane over time, and that can have a big effect on the implementation of those information quality guidelines.
Nikesh, it was rather dramatic contrast you drew between the first 6 months of John Graham's tenure at OIRA, returning 20 rules, and you said that was more than had been returned in the previous 8 years. Now, I want to know what inference to draw from that. You also said that John expanded the scope of inquiry, looking at toxicology, epidemiology. That alone might account for the bump up in the number of rules. It might be that it was that the standards and the executive orders were being applied more strictly, and it may be that, pardon me, essentially political differences between John and Sally, who preceded him, Sally Katzen, account for it. So what's your hypothesis, or what are you suggesting?
I actually worked in conjunction with Administrator Susan Dudley, but I could posit that I think it's a combination of all of those factors, and that, at least I know with respect to my experience working with Susan, I think by and large we didn't return, I think, any rules during the course of the time that I was there, and I think it was because I think some of the things that John had kind of established during his tenure there. I think the fact that by 2006 you were talking about the political factors. There are a lot of regulations I think that naturally in the byproduct that towards the end of administration get issued, and that the next administration that comes in decides they have other priorities and elects not to go forward with them, or decides not to proceed forward with them. By that point that Susan had came in 2006, there was a different atmosphere. It had been 6 years since the current administrations had changed over. And so I think it's a combination of kind of all those factors. At least I could speculate about what may have motivated John to kind of kick back as many as he did.
And I can add to that, Judge, too, that in the time I was there, I think the driver behind that spike in the return letters was exactly what John was saying, that, we felt the standards that were in place under President Clinton's executive order were sufficient for IRA to be effective. Every administration considers whether they ought to have their own new executive order, and the conclusion of the Bush administration was it was sufficient, but it should be enforced vigorously. And I think there was a more exacting demand on the quality of the analysis supporting regulation, and I think that was the driver. It wasn't, most of the staff were the same staff that worked in the prior administration. I think the difference was that their professional judgment was given greater weight.
Luke, how do I turn this on?
I'd like to take a more policy-focused approach to responding to that question, because during the last 12 to 13 years, there has been a steady paradigm shift in the approach of science in protecting, in securing environmental health protection. And that change has to do with the European Union's effort to establish international legal norms based on the precautionary principle. And when you delve into the precautionary principle in any great depth, you realize that it changes the threshold of science from that of straight line causation into nonlinear correlation. You have a weight of the evidence approach to scientific evidence that you did not have previously. You have shifting burdens of proof, and you have a focus more on hazard than risk. So we're talking about a standard that's changed from probability to more possibility, and that OMB would be called to be looking at these rules more closely, and as a result, maybe in fact rejecting a number of them if they're still adhering to the old risk-based standard, which most of the U.S. regulatory system has been based on historically, not on the new postmodern precautionary standard. I have written a lot on this based on my research, and I've done this with European lawyers who are very, very familiar with the effect of the precautionary principle on regulatory science.
Let me just ask for clarification. Were you suggesting that that shift would result in less stringent regulation?
I submit that that shift in paradigm would result in more regulations being triggered because the threshold of evidence has been lowered.
Okay,
for harm.
that's what I would expect. Okay, yeah, thank you. It was suggested to me by one of our former ambassadors to the European Union that the D.C. Circuit would eventually be able to enjoy a quiet life because everyone would be bound by the stricter standards of the European Union. Thus far, that doesn't seem to have happened yet, but I am stocking up supplies for that day. Should it come. Any other comments before we? This is about as good as a banana. Before we go to the audience, Nikesh, Paul? No. Okay. Glenn, Rick, right here. Rick.
Well, you've hit on a subject. I'm Richard Falk that I'm dearly attached to. I'm a Senior Director of Energy and Environment at the George Mason University Law School and a partner at Hollingsworth LLP. And the reason I'm concerned about this is because I've been looking for a long time for a manner in which to bring greater scrutiny to judicial review of agency scientific decisions. And one of the problems that's been discussed here is the UARG case, which is a classic example of where an agency's scientific conclusions were reviewed under the Baltimore Gas standard, namely a extreme degree of deference or super deference was given, and essentially an epochal decision about the endangerment of greenhouse gases was decided by super deference and never received any substantial review by the courts. And the question I have to this is, in addition to all the things that you've identified about the ways that this IQA issue may be useful, could it be useful in diffusing the requirement of extreme deference by saying that information and findings that don't meet that level of quality are not entitled to extreme deference that the courts otherwise give scientific conclusions?
That's a very good point. Again, the IQA is a process-based statute. It focuses on how science is developed and reviewed. But once you find that the process has been flawed through evidentiary submission, you then have to ask the next question. What is the science? What standards of evidence were used in order to secure the scientific result? Is the scientific result reproducible? Is it accurate? So yes, I think it could diffuse super deference at a petition for review under the substantive rule, and basically place the burden on the agency to come up with the evidence, which in this case, at the current time, it's not required really to do that. So, as you know, shifting a burden of proof in a lawsuit can can result in a different outcome.
Paul, when you say, is it reproducible, are you saying anything more than asking anything more than whether it is falsifiable by the standards of empirical science, or are you asking whether it in fact has been reproduced in subsequent or multiple trials?
Okay, I'm referring to empirical science as opposed to precautionary science, which is more forward-looking and anticipatory rather than observable science. Yes, obviously, the whole point of science is through experimentation and reperforming an experiment through a validation process that you do have a reproducible set of facts.
Well, that muddied the waters. That would give you a reproduced set of facts. I want to know, that's the question. Are you saying it has to have been reproduced, validated by more than one study, or that it has to just be empirically falsifiable in principle?
Okay, well, if we were to take your approach, then we could say, for instance, that a peer review process pro forma would be all that's
really
necessary.
Karl Popper's approach. Okay.
No, of course. Basically, for instance, the endangerment finding science, the agencies under the White House U.S. Global Change Research Program had merely provided pro forma evidence of the peer review processes of the various agencies, or even the international bodies. They never validated any whether even the processes were actually implemented as stated. So you have to go through, there's a difference between verification and validation in science, or even in engineering. It's, verification of an approach is, yes, I've restated the approach on paper. The question is, have you actually exercised that approach? So I guess from a process point of view, you could show that the peer review process for external peer reviewers had achieved a certain level of reproducibility and had a certain level of robustness. At the same time, the experiment of science itself, going through the motions, can provide a modicum of evidence that can be satisfying in judicial review.
So the way you've just put that, it sounds, if I understood it correctly, it sounds as if you're asking, would this peer review come out the same way if it were peer reviewed by another group?
On an IQA level, yes.
Yeah.
But when you get to the next question, is the science itself reproducible? That brings up, yes, reproducibility. Can another lab reproduce the outcome? Are there other computer models from independent third parties that come up with the same inputs and outputs?
Okay, the first one, can they? Didn't ask whether they have. The second thing you just said required that they have.
Yeah, in each case, they should show that they have reproduced it,
Okay.
both the process and the science.
So, for instance, in a recent case in our circuit involving health claims for pomegranate products, the FTC had required two state-of-the-art, essentially, double-blind protocol clinical trials. The court said that one was sufficient to support a health claim of that sort. But it sounds like you're saying that there have to be two.
I'm saying when you're dealing with signs that are designated as HISAs with over $500 million impact each, and when you have multiple assessments that undergird a major rule, yeah, that's a robust review.
Glenn, can we go out to...
We don't have any questions online, so if anybody has questions...
Look, right here, Jim Tosey, right here.
I would like to comment on Judge Ginsburg's question about review under the, I call it data quality, but it won't be named IQA. Anyway, I think the definitive statement is the D.C. Circuit, which is, the Supreme Court of the administrative law, is the prime time decision. And the prime time decision, and it said unequivocally the term binding. It didn't put anything before it after. It said the Data Quality Act guidelines are binding. Now, it didn't say legally binding. They said binding. And if you look at their citations, you could most certainly come up with a conclusion that they were legally binding. I wrote an article on that, and Justice Department went back to the judge to say that CRE said they were legally binding, and please amend the decision, and the courts did not. That said, I think the answer to Judge Ginsburg's question on the reviewability and the standard of arbitrary and capricious is one that a number of people have made, including Mr. Kogan in his treatise, is that I think the prime time decision would require that when you have a hard look review under arbitrary and capricious, you would incorporate the standards set forth in the Data Quality Act into that hard look review under under arbitrary and capricious. Doing that changes the ballgame quite a bit, because the guidelines say they must be reproducible and a lot of other activities. And I think that phenomenon, as soon as the prime time decision gets more ventilation, more legal scholars look at it, and put that as part of the hard look review under arbitrary and capricious, I think you're going to have a whole different position on how agency scientific decisions will be reviewed.
Are you that optimistic?
I am cautiously optimistic that that will eventually take hold, because again, the reason why the court held that it was binding was because of the public stakeholder input in the process of promulgating the OMB guidelines. Okay, they were promulgated pursuant to APA notice and comment, both the guidelines and the peer review bulletin. Many guidelines do not go through that process because they're mere interpretive guidelines. The Perez case in the Supreme Court that was handed down in the last several months makes that distinction. For that reason, the OMB guidelines are legally binding. The court was correct in its assessment, as you state, and it will have an impact on hard look review, because when you look again, the DC Circuit Court never really reaches the question of the accuracy or the quality of the science. It assumes it away because the agency is deemed to possess the expertise that the courts do not. An IQA action questions the agency's expertise in developing and reviewing the science. And if they cannot meet the prima facie requirement that they are in compliance with the standards, whether they be ISI or HISA being the most robust, then they should not be entitled to the deference that the DC Circuit would otherwise grant them. And arguably the burden should shift.
Paul, I want to ask you something, if I may. You referred to OIRA's function of coordinating standards among multiple agencies, or at least giving agencies other than the proposed issuing agency heads up and opportunity to weigh in. Now, that's always been, from the beginning in 81, that's always been part of the mission, but at least in the early years when I was there, it was far from accomplished. So to take the example of formaldehyde, Jim probably remembers, I think there were 7 agencies that had standards because, for instance, HUD had a standard because formaldehyde appeared in the interiors of manufactured housing. The EPA had a standard of exposure. OSHA had a workplace standard, and so it went. There were 6 or 7, and they were all different. Different tolerances for exposure, different implicit valuations of life. Has that been resolved over these years?
So, Judge, your question goes to where you have different agencies that have different standards on the books, and that's a very interesting and challenging example. When I was making my point, I was referring more broadly to this situation where you have an agency issuing a regulation on subject X, and there are other agencies that have expertise on that, and so they're brought into the interagency review to lend their views and expertise. But as far as straightening out so the use of science is consistent among different agencies, that is a more unique fact pattern, and something that I think any administration should be doing. Whether it happens in practice, I think I'm skeptical about that, because typically OIRA is in the mode of the transactions that come to it. It usually doesn't have the resources typically, or sometimes even the focus to go out proactively and straighten out a problem like that. Although I would say they should, and I think they should have the resources to do that sort of thing, because that makes perfect sense that the use of science among the agencies should be uniform.
One second, Nikesh, did you have anything on that?
Yeah, no, I agree with Paul that I think that's more kind of not almost to say defensive function, that they're kind of reacting OIRA OMB to kind of what's sent to them, rather than establishing kind of a proactive, affirmative agenda of saying, there are all these discrepancies or inconsistencies, and how do we reconcile them? And there was, when I was there was some discussion about actually engaging in that type of endeavor. It just simply, it didn't get off the ground, and it kind of got lost in the shuffle among other competing priorities. But it is something that I know that's kind of percolating out there, at least among some folks, about kind of how the administration, or how OMB can actually do that in a way that can kind of gather together where there are conflicting standards and make it a way that it's more streamlined.
Well, one thing that might be within OIRA's grasp, if they can't make uniform standards, would be uniform valuation of life. And has there been any effort at that?
You know, there are guidelines that are all administrations have had for how proper regulatory impact analysis should be done, and that includes how benefits are estimated. But I don't think there's been a step to the point of actually saying these health benefits are going to be valued exactly the same across agencies. I think there are differences to this day. And we have some members of the audience who have greater expertise than I do who can speak to that, who worked at OMB. But, you know, that is another good example of a conflict or an inconsistency that really doesn't make sense that exists to this day.
Larry, you want the last word?
Yeah, please, thank you.
Next to last word, pardon.
Looking at, again, the quality of the science that the agencies rely upon, either it's developed internally within the agency or externally through third-party development. The agency, the OMB, can serve a very important role if it cannot itself review the validity of that science or the process by which it was developed by either the agency or the third party. It can obviously outsource this, and that seems to be done these days to some degree by bringing in outside experts. But one of the interesting things is that the IQA guidelines defer to the National Academy of Science as providing a certain quality of science, and I believe that based on the evidence that I've uncovered, that presumption of quality should be removed and should be based on facts and circumstances. The National Academy of Science unfortunately, has become a politically motivated entity depending upon who tasks it with the job of either preparing the assessment or peer reviewing it. And OMB can play the independent arbiter here, especially if it brings in outside parties to assist it.
Interesting. There was a hand up in the back, but I didn't see a person attached to it.
Thanks, Judge. Mark Chenoweth, General Counsel, Washington Legal Foundation. My question would be, if IQA doesn't work, another alternative that's been suggested is some sort of regulatory Daubert standard. If a standard like that were enforced, or either by executive order or maybe this is less likely by legislation, would that be something that would be better enforced based on your experience by OIRA, or would it be better enforced as the Daubert standard is now in federal court?
That's an interesting question, because the IQA proponents do want to change the Daubert standard at trial court. Obviously, the standards have been distinct at the regulatory level, which is more anticipatory rather than post hoc relief provided at the trial court. One of the interesting things is that those who oppose the IQA oppose it because you can't introduce into Daubert review a precautionary principle rule at this particular point, because the evidence isn't there to show that it's reproducible. And what they're trying to do, and this happened in the First Circuit actually in the Acuity case that was decided in 2011, they used weight of the evidence standard to lower the threshold of evidence into which they then injected precautionary principle-based science. Now, Christopher Stone was the expert witness in that case, and he happens to be a fellow of the Center for Progressive Reform and is a great advocate of the precautionary principle and opponent of the IQA. So one of the things that needs to be closely examined is that, yes, the evidentiary standards must be maintained at the regulatory agency level, commensurate with the trial court, and efforts must be made at the regulatory level to prevent, or actually at the trial court level, to prevent the use, for instance, by an expert witness of a risk assessment based on weight of the evidence as opposed to straight line evidence, in order to prevent the change of the paradigm at the trial court level. So I think there's a great interaction here between what could happen at the agency level based on the evidence of science used in a risk assessment and what can then be cited as a basis for relief at the trial court in a Daubert hearing.
I would just add, personally, my favorite would be for Congress to simply codify in statute the basic presidential directive that every president since Jimmy Carter has
directed OMB to follow, which is, and the agencies, which is to make sure that federal regulations are doing more good than harm. That's essentially what it is. Maximize net benefits to the public. And I think if that were codified into law and subject to judicial review, that OIRA's job would be a lot easier and the interagency process would work a lot better about making sure there's high quality information, including scientific and technical information, and the policy choices that go along with that. It would be much easier to do that job. And not everyone agrees with that perspective, but I think it would be a tremendous improvement over our current regulatory system.
Of course, no regulation has ever come to court, and probably never to OMB, with the agency saying that the costs of this regulation exceed the benefits.
Yeah. Right, but if there's a provision in statute that requires this, I think there's going to be a lot more opportunity to look behind these analyses and these claim benefits. And that's what needs to happen, I think, to get greater objectivity into the system.
Well, it's quite apparent that optimism is what keeps everyone here going. We run out of that, we're out of business. Thank you, Glenn, for this opportunity for all of us.
Thank you, Judge. Thank you very much.